Okay, we are now live and on the record for this morning's civil docket. Okay, let me take a quick announcement. Adrian Lozano.
Good morning, Your Honor. I'm here on CL 21-3256I. It's an occupational license hearing against Javier Hinojosa. And
okay, what number is that on the court's docket?
Number 22, Your Honor.
Okay. All right, and what is your announcement?
Your Honor, I just have a few questions for the defendant.
Okay, and who's opposing counsel?
Justino Garza.
Okay, J.R. Garza. Mr. Garza, are you present?
I'm right here, Judge.
Okay, and is your client present?
He should be present.
Yes,
Yeah,
I'm
he's
here.
Okay, Mr. Hinojosa, can you please raise your right hand? And go ahead and, okay, do you swear that the testimony that you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Okay, go ahead.
Could you please state your full name for the record?
Javier Hinojosa Jr.
Why was your license suspended?
For driving intoxicated.
Okay. Was there an accident involved?
No.
Did you provide a breath sample?
No.
Do you know the result of the breath sample?
No.
Okay. When was this DWI?
It was a while back. Don't know the date, the actual date.
August 8th of 2021. I'm
Thank you.
sorry. Yeah, that's correct.
Is it still pending or did you plead guilty?
It's still pending.
Okay. Your Honor, at this time, the state does not have an objection to the occupational license being granted. Defendant has listed his jurisdictional restrictions and has specified the 12-hour shifts. There was no accident involved. However, the court shall require the defendant to attend the counseling/rehab program for the alcohol dependence, and it shall be stated on the order granting the occupational driver's license in accordance with Transportation Code 521.245.
Okay, Mr. Garza, do you have any questions of your client?
I do not, Your Honor.
Okay, and is that your agreement, Mr. Garza?
Yes, we're okay with that, Your Honor.
Okay, so then is he have a mobile device or an interlock device?
Sir, which one do you have?
Right now, I'm
Yes, sir.
using a mobile.
A mobile device? Okay. And Mr. Hinojosa, what is your phone number?
It's 956-579-1708.
Okay. All right, sir, then that'll be forwarded to my queue and I'll sign off on it, Mr. Garza.
Thank you, Judge.
Okay, anything else, gentlemen?
Just a comment, Your Honor.
Go ahead.
It's a good way to start my day when I see 3 pages of people waiting behind me and you call me first. Thank you, Judge. That's all I have.
Okay.
Thank you, man.
All right, then y'all have a good day.
You too.
Thank you, Your Honor.
Thank you. Ms. Orellana?
Good morning, Judge. I have one on your docket this morning, number 37.
Okay. Give me one moment. That's CL 21-0305-I, Edna Signs et al. Versus State Farm Insurance.
And I believe Mr. Mark Hanna is present for the defense here.
I'm present, Your Honor.
Okay, what's the announcement, counselors?
Your Honor, this matter settled about 2 weeks ago with the mediator.
Okay, great. How long do you think I'll need to wait for those documents?
It should be within the next couple of days. We're just, this is a UIM matter, so there's a severed case. We're still trying to obtain the cause number for that, and we should be able to get that done in the next day or two and then have everything filed within a week, I would guess.
Okay, I'm gonna set a tickler for December the 17th for those documents.
Sounds good. Thank you, Your Honor.
Okay, anything else?
I have nothing further, Your Honor. May I be excused?
Yes, Mr. Hanna?
Nothing, Your Honor. May I be excused as well?
Yes,
Thank you.
thank you. Okay, Mr. Martinez?
Good morning, Judge. I got number 11 on your docket. And my client is Dora Mendez.
Okay,
Judge, I had this question for this morning for a motion to withdraw that I filed. However, this past Friday, I'm gonna take that motion to withdraw back, Judge. I'm gonna withdraw it and informing the court that we'll be filing a notice of non-suit, Judge.
okay, so that's on F 2424-20-9 in the matter of the marriage of Feliciano Ambris versus Dora Mendez.
That is correct,
So,
Judge.
okay, so then you will not be urging your motion to withdraw at this time, and you'll file a notice of non-suit.
Yes, Judge. And attorney Robert Steindale is on board on that as well.
Okay, and when will you be filing that non-suit?
Actually, we just filed it. Mr. Steindale got me back the motion signed this morning, Judge, and I believe we filed it this morning. We just need to file the order with the court, and the court will allow it.
Yes, that's fine. Then go ahead and file your order. And I'll set a tickler for December the 17th, just to make sure that we've got it done.
Okay, we'll file that today, Judge.
Okay,
That's all.
all
Thank you.
right. All right, thank you. Okay,
You're
Mr.
welcome.
Reyes?
Good morning, Your Honor. Judge, I have number 40 on the docket. It's F476721-9. I represent Jorge Carrizales. This is a motion for temporary orders. It's an emergency motion that I filed based on my client not having any contact with his children. It should take no more than an hour. It's set for 11.
I represent the respondent, Jacqueline Escalante. I believe it's set for 11 o'clock this morning.
Yes, it is. Okay, so then you all are still moving forward with that?
That's correct, Judge.
Okay, well then check back at 11.
Thank you, Your Honor. Maybe we temporarily excuse.
Yes, you may be temporarily excused.
Thank you, Judge.
Okay, Miss Tony?
Yes, Your Honor. Number 25 on the docket.
F 2114-20-9, Juan Armando Campos versus Maria del Pilar Campos.
That is correct. I have Amber Van Schuber on the other side.
Okay, and is she present?
Good morning, Your Honor.
Yes.
Good morning. Okay, and what is the announcement?
Well, we're still conducting the discovery, and we still have a couple of things to provide to Ms. Van Schuber so that we can discuss the settlement.
Okay, so then you won't be moving forward with the final hearing today then?
No, Your Honor.
Okay, and how much time are you requesting?
30 to 45 days.
Okay. The earliest I have is February the 7th.
That's fine, Your Honor.
Okay, that's February 7th at 9:30.
Yes.
Okay, anything else?
No. May we be excused?
Yes, you may.
Thank you.
Thank you. Okay, Ms. Matter?
Morning, Your Honor. I am here on number 20 on your docket. Honestly, the hearing should take 2 minutes.
Okay, and that is CL 152753-I, State Farm versus Domingo Gomez et al.
Yes,
Okay.
it's a motion
and
to abate.
who is opposing counsel?
I do not believe that there is opposing counsel on this file.
Okay, Mr. Damian, will you call out Domingo Gomez and Adrian Tafola?
Yes, ma'am. Domingo Gomez, Domingo Gomez, Domingo Gomez. Adriana Tafoya, Adriana Tafoya, Adriana Tafoya.
Okay, go ahead.
Thank you, Your Honor. We have filed the motion to abate based on defendant Domingo Gomez being active duty military. We're just asking the court to abate this case until a time when he is no longer on active duty.
Okay, and do you have an order to that effect also filed?
Yes, Your Honor, it looks like it was filed on August 8th, so it should be attached to the motion.
Okay, that's granted, and we'll go ahead and sign that as soon as it's sent to my queue.
Okay, perfect. And I have nothing further for the court this morning.
Okay, ma'am. You have a good day.
You as well. Thank you. Take care.
Likewise. Okay, Mr. Velasquez?
Good morning, Your Honor. Sorry, I'm a little under the weather. I just wanted to let you know I'm also in county court at law number 8. I do have cases number 18 and 19 on your docket, and I wanted to ask permission to be temporarily excused until I finish up there.
Okay, no problem.
Okay, I'll be right back, Judge. Thank you.
All right. Okay, Mr. Flores?
Yes, Your Honor, we have number 4 on your docket.
Okay, F 1920-20-9 in the matter of the marriage of Jose Chavez Jr. and Ruby Hernandez.
Yes, Your Honor, I believe Arturo Garcia, who is the attorney for the petitioner, filed a motion to withdraw. We had already proved up this marriage, this divorce. The only thing that was holding us up was the amount of monthly child support, because there were some issues there. He had gotten a new job. We got all his stubs, and we calculated. I believe Isabel Trevino is also here representing the Attorney General's office.
That is correct, Your Honor.
Okay, and are the parties on as well?
My client is on, Ruby Hernandez. I don't know whether Mr. Garcia or his client are on.
Okay, Jose Chavez, are you present? Okay. No, he's not. Were you going to move forward with a final hearing today?
Yes, Your Honor, we'd like to get this thing resolved. We already approved up everything. We just needed the final amounts of child support, arrearages, and medical support.
Okay.
Like I said, we received the check stubs from Mr. Garcia, and I think the AG has already calculated the monthly amount, the step downs, and the monthly medical support, and also there's some arrearages that are owed.
That is correct, Your Honor.
Can my staff check to see if Mr. Chavez received notice for the hearing since Mr. Garcia had withdrawn?
Judge, the order setting hearing went directly to Mr. Garcia's office. If you give me a moment, I can contact Mr. Garcia to verify whether or not he gave his client or ex-client notice.
Okay, let my staff verify that, Mr. Flores, and then we'll recall you, because if Mr. Chavez didn't receive notice of today's hearing, we'll have to give him an opportunity to receive notice.
Okay, Judge.
Okay, so just be on standby until Ms. Rivera notifies me that she was able to contact them. I'll recall you shortly.
Thank you, Judge.
All right, Ms. Hopkins?
Good morning, Judge. How are you?
I'm doing well, thank you. Yourself?
I am good. I am set on the 11 a.m. docket. I'm number 39.
Okay. And are y'all going to be ready to proceed on that?
I have not communicated with opposing counsel. It doesn't appear that he's on here, and they haven't filed a response. So I'm ready to proceed. We've been continued quite a few times. I can check back with him between now and 11 and let the court know if he intends on appearing, or however you would like to handle it.
Okay, yes, go ahead and do that. And since you're set for 11, I'll call you at 11. So you're temporarily excused. But I believe that Mr. Pruneda is at MD Anderson with his wife. That was his announcement earlier last week.
Okay.
That he was going to be in Houston for 2 months.
Okay.
Due to his wife receiving treatment.
Right. And I would like to talk about this case a little bit more at the 11 o'clock docket if we can. If we're going to reset it, just want to get something final. But I'll reach out to Mr. Rayfield, and then I will get back to you at 11 if that works.
Okay, thank you.
Thank you, Judge. May I be temporarily excused?
Yes, ma'am.
Thank you.
Thank you. Okay, Mr. Rodriguez?
Good morning, Your Honor. This is on number 33 on the docket, Your Honor, and it's Galvan versus Spada. And I'm for the defendant. And I think opposing counsel is online as well.
Good morning, Judge. Rick Eckerson here for Bobby Garcia's office.
Okay, that's on CL 164015-I. And what is the announcement?
Your Honor, this is a status conference, is my understanding, and we were to report back to Your Honor about the case. And I don't believe we have a trial setting yet. And I don't know if you're providing that yet, Judge, but.
Okay, so everything's been worked up on this case, including attending mediation?
Yes, Your Honor, unsuccessful, but we're informally still negotiating. And we have now experts that need to be deposed. And it was difficult in December to do that, but we intend to set that in January.
Okay. Well, what I'll do is I'm going to set you for status for February the 7th. And if you still need a trial setting, go ahead and file your DCC. We are conducting those already.
Thank you, Your Honor.
Thank you, Judge. May be excused.
Yes, you may.
Thank you. Have a good day, Judge.
Likewise. Okay, Mr. Flores and Mr. Trevino, the petitioner in your case did not receive notice of today's hearing.
Okay.
So I don't know how you can get his contact information so that you can submit an order resetting final hearing and CC him. You might need to use his mailing address.
Well, Your Honor, did Mr. Garcia withdraw after all?
Hold on.
I think the order was just signed last week.
I believe I did.
An order.
Yes. I'm sorry, Ms. Castaneda, what?
Yes, there was an order signed of his withdrawal was signed.
So yes, Mr.
On the 3rd, ma'am, November 3rd.
Let's see.
Okay. So the order for his withdrawal was signed on November the 3rd?
Yes, ma'am.
Okay. So then if you can please submit an order resetting final hearing and have his address put on there, that's the best that you'll be able to do unless Mr. Garcia has an email address for him.
No, all I have in his motion to withdraw, he has 1707 Audrey Drive in Mission.
Okay. Then I would suggest that the order resetting final hearing has that address.
Your Honor, how soon can we get this hearing done? Because my client's not receiving any child support from this gentleman. He's behind a lot of money.
Well, when they do, when they have the address on the order setting hearing, we usually set it out for 4 to 6 weeks so we can give time for the clerk to mail it and for them to do it. So when you submit it, I'll look to see if we can fit you in on the January 12th docket.
Okay, I'll be fine, Judge.
But that would be the earliest that we would be able to do.
Okay, Your Honor.
All right.
Thank you, Judge.
Okay, thank you. And you all are excused.
I have another case, Judge, so I'm going to wait on.
Okay, what case is that?
Did I have number 7?
All right, F3326-04-9 in the interest of minor children, Attorney Gilbert Vasquez. Okay, Mr. Vasquez?
Yes, Judge. I'm sorry.
All right, so Ms. Trevino's here from the AG's office and the other opposing party, are they pro se still?
I believe so, Your Honor.
Okay, and what is that name?
It's Ricardo Rodriguez.
And Mr. Vasquez, what's your client's name?
Her name is Irene Jeanette Rodriguez, Your Honor. She is online. I saw her earlier.
Okay.
Irene Rodriguez.
Mr. Damian, call out Ricardo Rodriguez, please.
Ricardo Rodriguez. Ricardo Rodriguez. Ricardo Rodriguez.
Okay, there's no one responding by that name. Are you moving forward on your motion?
Judge, in this case, a motion for enforcement was filed on behalf of Ms. Irene Rodriguez back on August 16th, 2019. This is a child support payment plan only case.
Okay.
The youngest child emancipated on August 18th, 2017. The motion for enforcement was timely filed. It was within the 2 years. But since it is a motion for enforcement, the non-custodial parent needs to be present. The Office of the Attorney General intervened with a motion to confirm arrears. We can go forward on that without his presence, but on the motion for enforcement, he has to be present.
Okay, Mr. Vasquez, do you want to take care of the confirmation, or do you want to do it all together?
Let's go ahead and proceed with a confirmation, Your Honor. I don't have a problem with that. I'm just concerned about getting a hold of him. I know that he gave a new address about 2 hearings ago. The Attorney General's office confirmed that he gave them a new address. So we've been sending notice to that address, but this is the second time or third time he has not responded. That's the only thing, but just to give you notice of that, and we will try to get a hold of him for the next hearing, for our hearing.
Yes, I don't know, Your Honor, if this would be a proper case for a capias or not, not knowing when the notices went out.
The last time we were here was I think it was in September, Your Honor, and I think that's when we confirmed that he's the one that gave the new address to the Attorney General. We did not. If we can issue a capias, I would like that, Your Honor. This guy has just been playing games with us since we filed this, and it's just a mess. I mean, we'd like to, the last time we were here was October the 27th. So if we can issue that capias and let him know this is serious, he's got to stop this.
Let me go ahead and, hold on, let me review your motion for enforcement real quick.
Yes, Your Honor.
Ahí arriba. Oh.
On what date was that motion for enforcement filed?
It was filed on August 16th, 2019.
Okay. Now you filed your order to appear on that one. But was there an order to appear with enforcement language sent out for today's date?
Today was set for final hearing, Your Honor.
No, I understand that. But on the motion for enforcement, if you're going to issue a capias, there has to be an order to appear with the language as like the way that it was sent out back originally. Was there one sent out for today with that same language?
No, Your Honor. It's just
Judge.
Okay. So it would be right for a capias if it was if it had that language on there. We can set it for you if you want to file an order to appear, and with the enforcement language and that in there to be mailed to his last known address. At that time, if he doesn't show up, the capias can be issued at that point.
That would be a show cause order, Your Honor?
Yes, a show cause order.
I'll do that, Your Honor. Thank you.
Okay, so then do you want to proceed on your confirmation hearing?
Judge, we can do it all at the same time.
Okay, that'd be best.
Okay, Your Honor.
Okay, so go ahead and get that filed and then we'll get it set for you.
Yes, Your Honor. May myself and my client be excused, Your Honor?
Yes, sir.
Thank you, Your Honor. You have a good day.
You're welcome, Mr. Trevino.
May I be excused, Your Honor?
Yes.
Thank you so much, Judge.
Okay, Mr. Garcia,
Yes, Your Honor. Good morning.
good morning.
I'm here from the Bobby Garcia's law office. We tried to get the docket number, we couldn't, but I do see the attorneys, defendants' attorneys here on the screens. It's CL 20-28-26I. It's Saúl Mesa Garcia versus Kayla N. Alvarado. Arevalos. Excuse
Okay,
me.
that's number 24 on the court's docket, and the Mr. Denzer is present.
And so I
I'm
saw
present,
Daniel
Judge.
Sorrells too, Your Honor.
Judge, I'm here, Nick Denzer for defendant Kayla Arevalo, only for her defendant claims.
Good morning, Judge Daniel Sorrells. I'm here for Kayla Arevalo, sorry, Judge, on her personal injury on a counter plaintiff, Judge, and also for the 2 passengers in her vehicle, Judge.
Okay, and what is the announcement?
Your Honor, what I understand, we're still ongoing and we're trying to set depots. Other than that, nothing has been completed. Other than maybe we need a trial setting.
Okay, Mr. Denzer?
Yeah, we've exchanged written discovery. Mr. Ralph Rodriguez, I don't know if he's still on. He was here for that earlier hearing. He came into the case recently for plaintiff as defense counsel. But written discovery was recently exchanged between all the parties, I believe, and we need to move forward with depositions.
I concur, Judge. On the plaintiff side, we just got served with written discovery last week, so we'll start answering that, Judge.
Okay. So the last time that we were here, I think you all were going to try to make some progress on depositions and the written discovery. So let's go ahead and come back on February the 7th at 9:30. And let's see how far you've been able to get.
That would be a status hearing, Your Honor.
Yes.
Thank you.
Okay, anything else?
Not from me, Your Honor.
Nothing from me, Judge.
Nothing from me, Judge.
Okay, y'all have a good day.
You too. and
You too,
stay
thank
safe.
Judge.
Thank you. Okay, Mr. Morales? Mr. Morales?
Yes, Judge, I'm here.
Okay, what number?
Judge, I don't know the number. It's F 2129. And Melissa Canales is on the other side. I just spoke to her.
Number 28, Your Honor.
Okay,
We're just gonna make an announcement, Judge. We'd like to have maybe a short hearing in front of the court just to finalize this. If whenever the court it's convenient for the court in January or February.
okay, and it'll be a contested final hearing?
Yes, Judge.
Okay, have y'all already attended mediation?
Yes, we did. It was not successful, Judge. It's just going to be an issue of the percent of the residents, Judge. That's the basis of the community property.
Okay. Go ahead and file an order resetting, an order setting final hearing. And please
Okay.
indicate in there that it will be a contested hearing and how much time you think you will need. And
Okay.
then we'll go ahead and get that set for you.
Okay. Thank you, Judge. May I be excused?
Yes,
Thank you.
okay. Mr. Sorrells, did you have another announcement?
Yes, Judge, I did. I'm here on a friendly seat on number 9. I know Jose Ozuna is the ad litem and I see him here on Zoom. My clients are also here on Zoom. I'm not sure. I believe it's Hector Torres who's on the other side. I'm not sure if somebody's here on his behalf, Judge.
Good morning,
Okay.
Judge. I'm sorry, excuse me,
Go
Judge.
ahead.
This is Rogelio Garcia, and I am standing in for Mr. Torres.
Okay, and are we missing anybody? What about Miss Kennedy?
Judge, I believe Miss Kennedy, we non-suited her, Judge,
Okay,
her client. So I believe everybody's here on Zoom. And Judge, for the record, my clients are the parents of Marcelo Herrera, the minor. They won't need the services of an interpreter.
okay, and what are your clients' names?
Judge, it's Marcelo Herrera, I guess, senior. They're under law office of Rogelio Solis, unless they just got knocked out of Zoom. Oh, they're here, Judge.
Okay. And what is mom's name? Are both parents testifying?
I just need one, Judge. It would probably be senior. That's the one that I met with.
Okay,
Your
well,
Honor-
he's not
Your-
on the screen.
Your Honor, the style of the case has Miss Alejandra Rodriguez as the next friend of the minor Marcelo Herrera.
Oh, then it has to be her.
Okay, she should be there, Judge. I just told my office to unmute and put the video on.
Well, is that her raising her hand?
I'm the parent of Marcelo.
Okay, perfect, Judge.
Herrera.
There we go.
Okay, so what is your name, ma'am?
You're back on mute.
You need to stay unmuted. Click the microphone again. Okay, what is your name, ma'am?
Alejandra Rodriguez.
Okay, perfect. All right, Mr. Osuna, are we ready to move forward on this case?
Yes, Your Honor.
All right, let me call CL 20-3480-I, Marcelo Herrera versus Laura Denise Hassel et al. All right, Ms. Rodriguez, let me go ahead and have you raise your right hand. Do you swear that the testimony that you're about to give is the truth, the whole truth, and nothing but the
Yes.
truth, so help you God?
Yes, I swear.
All right, okay, you may proceed.
Judge, if I could go first, I think I can knock out most of the questions.
Go ahead.
Yes, based on the circumstances, I believe it'd be best for Mr. Sorrells to go forward.
Okay, go ahead.
Okay, could you please state your full name for the record?
My name?
Yes.
Alejandra Rodriguez.
Okay, and how are you related to Marcelo Herrera?
I'm the mother.
Okay, he was involved in a motor vehicle accident, correct?
Correct.
And he was a pedestrian and was hit by Miss Hassel, correct?
Correct.
As a result of that collision, Marcelo suffered some pretty bad injuries, correct?
Correct.
And he treated for those injuries, is that right?
Right.
Since the accident, has the treatment that he's gotten from the medical providers helped him in recovering?
It has helped him, but he still needs a little help.
Okay. In fact, he does have, or you guys are planning on getting him another surgery here in the future. Is that right?
Yes, he still needs something to be removed from his leg. Metal.
All right. We brought a claim against the driver of the vehicle. Do you understand that?
Yes.
Okay. You also understand that she has a $30,000 policy. Is that right?
Right.
Okay. Marcelo's medical bills were well over $150,000. Is that right?
Yes.
And you understand that we have included all of his medical providers in this lawsuit. Is that right?
Yes.
We obtained default judgments against some of those medical providers, and others agreed to take to reduce their bills down to zero. Do you understand that?
Yes.
You understand that out of the $30,000, that $7,640.92 will be paid to McAllen Medical Center. $700 will be paid to McAllen Emergency Medicine. $30 will be paid to RFC Radiology. $743 will be paid to RGV Critical Care PA, and $1,569.08 will be paid to the Rawlings Company, which was a health insurance provider. Do you understand that?
Yes.
Okay. Of the amounts left over, $9,317 will be paid to law office of Rogelio Solis as attorney's fees and expenses. Do you understand that?
Yes.
Which leaves $10,000 left over for the benefit of Marcelo Herrera. Do you understand that?
Yes.
Okay. Do you understand that you do not have to accept this settlement, that you could reject it, take it to a jury trial, in which case you may get more, you may get less, you may get the same thing on behalf of Marcelo? Do you understand that?
Yes.
Do you believe that entering into this settlement, as we just discussed, is in Marcelo's best interest?
Yes.
You're asking the court to approve of this settlement?
Yes.
You understand that normally the $10,000, which is the portion for Marcelo Herrera, would go into the registry of the court?
Yes.
But you guys, I believe, are going to be asking for that money now so that you can use that to pay for the further medical treatment for Marcelo Herrera instead of putting it on a credit card or some other means. Is that right?
Well, we would like it, but at the time when he needs to get the other surgery.
When are you planning on getting that other surgery?
We still need to speak with the doctor.
Okay. All right. Are you satisfied with our services as your attorney?
Yes.
I'll pass the witness, Judge.
Okay, Mr. Where did you go on my screen?
Garcia,
No, I know, but I couldn't find you on my screen. Okay, Mr. Garcia, go ahead. Do you have any questions?
just a couple of questions, Your Honor. I understand, Ms. Rodriguez, that your son, Marcelo, is 17 years old, correct?
Correct.
He'll turn 18 on September 9th next year?
Yes.
Okay. And do you understand that a document that is going to be presented to you that's called a settlement agreement release that we're going to ask you to sign, or your attorney will ask you to sign, will discharge Ms. Hasso from any future litigation, any future claims, and that these are all the funds that will be available for Marcelo based on her policy limit? Do you understand that?
Yes, I understand that.
Okay. Ms. Rodriguez, that's all I have for you. I wish you and Marcelo the best. Thank you.
Thank you.
I'll pass the witness, Your Honor.
Okay, Mr. Osuna, do you have any questions?
No, Your Honor, I do not.
Okay, so Mr. Osuna, have you had an opportunity to review the settlement agreement?
Yes, Your Honor. We closely considered the agreement in light of all the circumstances, the anticipated return, liability issues that existed, considerable medical bills, and the fact that they've been reduced, and the young man's current condition and his progress so far. And we do believe that it is in the best interest of the child for the settlement to go through.
Okay, and do you have any concerns or objections for the money to be released now to the child instead of being put in the registry of the court?
No, Your Honor. The anticipated operation date is in February. The estimate is about $5,000, barring any complications. I've spoken to parents. If there is a remainder, they would set that aside for his secondary education. He is an exceptionally bright young man, and I do believe that the parents have his best interests at heart.
Okay, and Mr. Garcia, has the ad litem fee already been negotiated?
Yes, Your Honor, that has been negotiated, and it's already been included in the final judgment that was circulated, pending signatures, as well as the drafting instructions, I think, will have to be revised, Your Honor. So I'd ask Mr. Sorrells to provide me with those revised drafting instructions if the court is going to be allowing the $10,000 to be dispersed to the parents for the young man's future surgery.
Okay, the court is going to grant Ms. Rodriguez's request, and we'll go ahead and release the balance that is going to be for the child to the parents for the use of the surgery, and any balance that isn't paid for the surgery shall be used for the benefit of the child. Do you understand that, Ms. Rodriguez? Ms. Rodriguez, do you understand that?
Yes.
Okay. And so the court will also accept the settlement agreement as testified to onto the record. Go ahead and circulate a new order with everything as has been ordered by the court. And I'm going to give you all until the 17th to submit that.
Thank you, Your Honor. Again, I've asked Mr. Sorrells to provide me with these drafting instructions as quickly as possible. That way I'll revise the final judgment and recirculate with the language that the court has just ordered.
Okay, well, go ahead and get that done, please, Mr. Sorrells.
Yes, Judge, I'm doing it now, so you should be getting in about 30 seconds, Judge.
Okay, perfect. All right, anything else, gentlemen?
Nothing from the plaintiff, Judge.
That's all that I have before your honorable court, Judge. Thank you.
Nothing further, Your Honor.
Okay, thank you. Y'all have a good day, Ms. Rodriguez. Best of luck to you. And I hope that your son's surgery is a success.
Thank you, Judge.
Okay,
Thank you, Your Honor. Thank you.
all right, you're welcome. Mr. Lopez?
Good morning, Your Honor. May it please the court, we're number 32 in your civil docket. Opposing counsel is Mario Garcia for local counsel for the defendant, Your Honor. It's set for status this morning, but I was looking at the docket. They also had filed a motion for lack of jurisdiction in the court. So I'm asking for a February setting so I could file an answer to what they filed, Your Honor. My client's she's on Zoom also, Ms. Puente, Your Honor.
Okay, this is on CL 200202-I, and who's opposing counsel?
Local counsel Mario Garcia, Your Honor.
Your Honor, good morning. Mario Garcia here on behalf of Defendant Ovation Services LLC. Your Honor, this is a case we were set for a status hearing back in October. However, there was a rescheduling to today, and we did file in the interim defendant's motion to dismiss this case for lack of jurisdiction. This case stems from a default judgment that was taken back 2017 on May 30th in front of the Honorable Judge Rose Reina, 206th District Court. So this case should not be in this court. So before this court, all appeals have run out, all deadlines. So we're asking the court to dismiss this case. We had set this, filed the motion to dismiss. We'll leave it up to the court if she wants to hear it now or at a later date, Your Honor.
Okay, so they filed a motion to dismiss for lack of jurisdiction back on October the 22nd. However, there was not an order setting hearing for that. So I need an order setting hearing on that motion, and we'll take it up at that time.
Yeah, and the plaintiff will be filing something to counter that because we do believe this court has jurisdiction. I'll explain that in my petition, Your Honor. We'll serve them.
So go ahead and have them file that order setting hearing on their motion, and then we'll give them a date.
Okay.
Thank you, Your Honor. May I be?
Your Honor.
Yes.
Have a good day, Your Honor.
Thank you. All right, Mr. Ruiz.
Good morning, Your Honor. Mauro Ruiz, we're number 26 on your docket. I represent Sandra Guerra, the plaintiff. This is the status conference.
Okay, CO 195846-I, Sandra Guerra versus Discovery Clinical Trials et al. And who is opposing counsel on this?
Your Honor, Paul Simon for defendants.
Okay, and what is the announcement, gentlemen?
We're ready to move forward with the status conference, Your Honor.
Okay, but I need the status. Did mediation occur?
No, Your Honor. Defendant opted to file a motion for summary judgment, which has not been set by the court yet. There has been no mediation.
When did that motion for summary judgment get filed, Mr. Simon?
Your Honor, give me one moment. Looks like October 6th, Your Honor, and then I believe a week or two after we filed an order setting summary judgment hearing, but have not received a date yet for that.
Okay. let me see. Okay, so you filed an order setting hearing back on October 18th,
Correct.
and I'll ask for that to be sent up to us because our queue has been cleared several times since then, and it hasn't come through yet. So that'll have to be requested. Okay, so we'll request the order setting hearing on your motion for summary judgment, and we'll get that set for you. And then, so let's get that motion for summary judgment hearing done, and then y'all can proceed accordingly.
Thank you, Your Honor.
Quick
Okay,
question, Your Honor.
Go ahead.
Does the court know when it will be setting that summary judgment hearing? Is it on the December or January calendar, or even February for that matter?
It's realistically, it'll probably be in February.
Thank you, Your
Our
Honor.
January dockets for both civil and criminal are packed at capacity already.
Understandable, Your Honor.
So you're probably looking in February. But we'll go ahead and get that requested. Ms. Castañeda will request that. Okay, so I'll just go ahead and we'll see you your next hearing. We'll be at the summary judgment hearing.
Thank you, Your Honor, and happy holidays. May we be
Thank
excused?
you. Likewise, yes, you all may be excused.
Thank you.
Okay, and Mr. Metcalf?
Good morning, Your Honor. Number 13 on your docket, CL-20-4172-I. Plaintiff's counsel is present. He and I have spoken briefly. It's Defendant Candy Reed's motion for summary judgment and motion for severance.
Good morning, Your Honor. Juan Pequeño. I'm standing in for Mr. Greg Kerr. Our office represents Mr. Jorge Hernandez, the plaintiff in this case.
Your Honor, Alan Irwin, I am here on behalf of the co-defendant, Long Island Village Owners Association.
Okay, and are you all ready to proceed today?
Yes, Your Honor, we are, or at least Defendant Reed is, and I think plaintiff is as well.
Yes, Your Honor. This is set for Defendant Candy Reed's motion for summary judgment and motion for severance. We did not file a response. We don't have any opposition to the motion for summary judgment as to that defendant or the severance.
We have no opposition to it, Your Honor.
Okay, well, since it's an agreed motion, just circulate the order for their signatures, and then
Your Honor, a proposed order was filed on the motion on September 3rd, and then a proposed order was filed on the motion for severance on October 27th. You want us to prepare a new order and have it as an agreed order?
Yes,
Okay.
so that you can have the attorney's signatures on it, and then when you submit that agreed order with everyone's signatures approving it, then I'll ask for it to be forwarded to my queue for my signature.
Okay. I will do that, Your Honor.
Okay?
Thank you so much.
That's all we have, Your Honor. Maybe be excused.
Yes, sir.
Thank you very much. Good to see you.
Thank you, Your Honor.
Thank you. Y'all have a good day.
You too.
All right, Mr. Velasquez, are you ready?
Yes, Your Honor. Excuse me, like I mentioned, I was a little bit under the weather. I have number 18 and 19 on your docket, Judge.
Okay, CL 210035-I, Bank of America versus Eric Zapata.
Yes, Your Honor, and those are both set for default judgments, Your Honor. I do believe the defendants are both pro se.
Okay, we'll take it a case at a time just to make a clear record. I'll go ahead and have my bailiff call Eric Zapata's name out 3 times.
Eric Zapata, Eric Zapata, Eric Zapata.
Okay, give me 1 moment. Okay, you may go ahead and proceed, sir.
Thank you, Judge. Your Honor, we're seeking $3,052.58 this morning in damages This amount arises out of a Bank of America credit card. The last 4 digits of the card number are 3820. The defendant has been duly cited and provided a copy of plaintiff's petition, and both citation and petition have been on file with the court for the requisite time. This account in brief was opened on or about December 28th of 2016. The amount of charge off again was $3,052.58. That occurred when the defendant then failed to make his timely payments and the account was charged off. The charge off date is August 31st of 2019. Since that time, we have not been able to reach a resolution with the defendant and are asking the court for judgment in that amount.
Okay, the court will take judicial notice of the documents in the court's file. Specifically, that defendant failed to file an answer, was duly served, and also failed to appear today. The notice for today's date went to his last known address, and the court will grant the relief as requested on the record. And I'll request the order that you're asking for me to sign is the one you filed on July 21st.
Yes, Your Honor.
Okay, we'll request that to be sent up to me for signature.
Thank you, Judge.
Okay, and now I'm going to call CL 21-2158-I, NAFT Federal Credit Union versus Zulema Rosas. And Mr. Damian, please call out Ms. Rosas' name 3 times.
Yes, ma'am. Zulema Rosas, Zulema Rosas, Zulema Rosas.
Okay, the name being called out 3 times and no response, you may proceed.
Thank you, Your Honor. This morning, we are seeking damages in the amount of $13,430.95. The defendant has been duly cited and provided a copy of plaintiff's petition that has already been filed with the court and been on file for the requisite time. This account arises out of a promissory note for a vehicle, Judge. The defendant defaulted on that note, and the defendant, this collateral was repossessed and sold. All the required documents that gave the defendant notice of the sale and the accounting of the sale and credits have been on file with the court. So I would ask the court to admit those documents as evidence this morning. In addition to that, Judge, we are seeking cost of court, and we are seeking interest at the allowable rate.
Okay, the court will admit the exhibits and also will approve the judgment as put on the record and take judicial notice of the documents in the court's file.
And one last thing to tie up, Your Honor, the defendant was served with a copy of or served with notice of this morning's hearing by certified mail, return receipt requested, and also by first class mail. I am looking at a copy of that green card. So Judge, it's defendant was duly served.
Okay. And the court will also take judicial notice of that.
Thank you, Your Honor.
Okay, go ahead and we'll ask for that order to be sent to my queue.
Yes, Your Honor. That's all the business I have before your court this morning. May I be excused?
Yes, you may.
Thank you, Judge.
Okay, Mr. Davis?
Yes, ma'am, Judge. I'm here on number 27 on your docket.
Yes, F 4121-19-9 in the matter of the marriage of Gabriela Flores and Ramon Flores, and Mr. Ball is present as well.
I'm right here, Judge.
Yes, so this is the case that was pending a ruling on the division that you all briefed, is that correct?
Yes, ma'am.
Okay, and I have never received any kind of cooperation as I tried to, because I was trying to go the extra mile and speak to them at that organization. And I don't know if they just don't want to speak to me or what the situation is, because I've tried more than several times to try to get somebody to speak to me about it, and they haven't. So what I'm going to do on this, unless y'all have come to an agreement.
No, Judge. If they're not responding, could I see if I could get my client to have them call into the court? He may have some kind of contact over there.
Yes.
That can make that happen. I don't know.
If he does have somebody specific, yes. But what I was also going to suggest is that, so you all have an agreement as to everything except for that. Is that correct?
Yes, ma'am, that's correct.
Okay.
That's right.
And so yes, I'm gonna give you go ahead and do that if you think that your client will be able to be more successful with that than me.
I don't know, Judge, but we'll give it a go.
Yeah, because I also don't want to make you all file competing divorce decrees. That's a lot of work. Okay. So what I'm gonna do is I'll give you an opportunity to do that. And I'm going to set a tickler for the 17th just to see if they were able to get in touch with me. And then I'll decide what the next step is at that point.
Very well.
Okay.
Okay.
And so I'll wait to hear from you all, and then I'll let you all know by the 17th what we'll do. Hopefully I can speak to somebody before then.
Okay.
Sounds
All
good.
right.
Thank you, Judge.
Okay, thank you. Y'all have a good day.
Bye-bye.
Okay, Ms. Guerra?
Yes, Judge, good morning.
Good morning, go ahead.
I'm on number 3 on your docket, Your Honor. It's cause number F380299 in the matter of the marriage of Maria Escobedo and Sonia Brenes.
Okay.
And opposing counsel, Eden Ramirez, I believe is on. I haven't seen him, but I've been texting with his paralegal.
We're on.
I did see Mr. Ramirez.
There he is.
Okay.
Yes, Your Honor, we're on here.
Okay,
Yes,
and
Judge.
are y'all ready for a final hearing?
Yes, Your Honor. I represent the petitioner and Mr. Escobedo is not on, but we have agreed that I can ask his client questions. However, she needs an interpreter.
Okay. And Ms. Brenes is with you right now, Mr. Ramirez?
That is correct, Your Honor. She's here across the table from me.
Okay. And then all I'm gonna ask is that you just go slow, Ms. Guerra, so that my translator can go ahead and translate that for you. So
Yes,
Ms. Brenes, will you please raise your right hand, Ms. Castañeda?
Sonia Brenes, por favor, levanta su mano derecha.
Okay, do you swear that the testimony that you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
Jura que el testimonio que está a punto de dar es la verdad, toda la verdad y nada más que la verdad.
Sí.
Yes.
Okay, go ahead, Ms. Guerra.
Okay, yes, good morning, ma'am. Can you please state your full name for the record?
Por favor, ¿puede decir su nombre completo?
Sonia Nelly Brenes.
Sonia Nelly Brenes.
Okay, and Ms. Brenes, when this divorce petition was filed in 2019, you lived in Hidalgo County for 90 days and Texas for 6 months. Is that correct?
Cuando usted metió esta petición en el 2019, usted vivía en el condado de Hidalgo por 90 días y en el estado de Texas por los precedentes 6 meses, ¿correcto?
Ya, conteste eso.
Sí.
No, conteste.
No.
No?
She may be confused because I didn't object to the translation because it's not a big issue otherwise, but she did not file the petition. Mr. Escobedo did. So let me re-ask the question if I may.
Okay, go ahead.
Okay, Ms. Brenes, when this petition was filed by Mr. Escobedo in 2019, at that time, had you been living in Texas for at least 6 months and Hidalgo County for at least 90 days?
Ms. Brenes, en el 2019, cuando el señor Mario Escobedo metió la petición del divorcio, usted ya había vivido en Texas por los precedentes 6 meses y en el condado de Hidalgo por los precedentes 90 días.
Sí.
¿Cómo dijo? No lo entendí.
¿Puede
repetir, por favor?
Cuando el señor Mario Escobedo metió la petición del divorcio en el 2019, 2019, usted ya había vivido en Texas por los precedentes 6 meses y en el condado de Hidalgo por los precedentes 90 días.
Sí.
Yes.
Okay, and you and Mr. Escobedo have reached an agreement regarding the property division.
Y usted y el
of the
señor Escobedo
marriage, is
ya
that
han llegado a
correct?
un acuerdo con respecto a la propiedad. Yes.
Okay, and part of that agreement is that Mr. Escobedo was awarded the property located at 3913 Everglade in Westlake, Texas. Is that right?
Y parte de ese acuerdo es que el señor Escobedo se va a quedar con la propiedad que está en el 3913 Everglade Drive en Westlaco, ¿correcto?
Sí.
Yes.
And in exchange for your interest in that property, you were to receive $40,000, which has already been paid to you as of this date. Is that right?
Y a cambio de ese acuerdo, usted iba a recibir una cantidad de $40,000 que ya se le pagó, ¿correcto?
Sí.
Yes.
And you have agreed to sign, and you already have signed a special warranty deed awarding him 100% interest in that property.
Y tocante a ese acuerdo, usted iba a firmar una escritura de garantía dándole al señor 100% de la propiedad y ya se firmó, ¿correcto?
Sí.
Yes.
In addition, Mr. Escobedo is keeping a Toyota Camry and everything that is in his possession. Is that right?
Y el señor también se va a quedar con una Toyota Camry y todo lo que él tiene en cosas personales, ¿correcto?
Sí.
Yes.
You are keeping everything in your possession, including some items that you retrieved from the house on Everglade that are already also in your possession.
Y usted se va a quedar con lo que tiene en su personal propiedad y algunas cosas que ya recogió de la propiedad de Everglade, ¿correcto?
Sí.
Yes.
Okay, ma'am. And now there were no minor children born of the marriage. Is that right?
Y no hubo niños, no hay niños menores que nacieron de este matrimonio, ¿correcto?
No.
No.
Okay, and you are not pregnant at this time. Is that right?
Y en este momento usted no está esperando bebé, ¿correcto?
No.
No.
And Mr. Escobedo, and you have agreed to ask the court for a divorce based on irreconcilable differences, correct?
Y usted y el señor Escobedo le están pidiendo a la corte el divorcio por irreconciliables diferencias.
Sí.
Yes.
Okay, and in October, you went to your attorney's office and I was present and you signed a final decree of divorce and a special warranty deed. Is that right?
Y en octubre usted firmó el decreto final y también la garantía de la propiedad, ¿correcto?
Sí.
Yes.
Are you asking the court to award you a divorce and based on the terms just read on the record?
Y usted le está pidiendo a la corte que le otorgue el divorcio con los acuerdos que hemos hecho aquí en la corte?
Sí.
Yes.
Okay, Judge, I pass the witness.
Okay, Mr. Ramirez, do you have any questions of your client?
No, Your Honor, no further questions.
Your
Okay.
Honor, I have a question. We filed a decree on October 26th and it was returned to us, but I didn't get a notification as to why it was returned.
Because if the decree is filed too early before the final hearing, the clerk will return it and then we'll have to request it again after the final hearing.
Okay, Your Honor, I will resubmit that then. I just wanted to make sure there wasn't anything lacking or that the court wanted, but I appreciate it. Thank you.
I don't think you have to.
No, Judge,
You don't
we
have to.
resubmit. We just have to request it from the clerk.
Correct. What we'll do is we'll request it from the clerk. You won't need to refile it, Ms. Guerra.
Okay, all right, great. Thank you so much.
Okay.
May we be excused, Your Honor?
Hold on, I haven't pronounced them divorced yet.
I'm sorry.
That's okay. Okay, the court accepts the testimony and will approve the agreement as testified to on the record, will further take judicial notice of the documents in the court's file and pronounces the parties divorced. And as soon as Ms. Castañeda will request that final decree of divorce to be forwarded, and I'll sign off on it as soon as it hits my queue.
Great. Thank you, Your
Okay.
Honor.
So, Ms. Castañeda, please wish Ms. Brenes the best of luck, and that we hope everything turns out well for her.
Ms. Brenes, la corte le desea buena suerte y que todo le termine bien.
Gracias, buen día.
Thank you.
And the same for your client, Ms. Guerra.
Thank you, Judge. Appreciate it.
All right, y'all are excused. Thank you.
Thank you. Have a great day.
Thank you, Your Honor.
Likewise. Yes, okay. Mr. Davis, I'm sorry, did you have another? Oh, you're at 11 o'clock. That's right, I forgot. Okay, Ms. Padilla, go ahead.
There we go. Good morning, Your Honor.
Good
I'm
morning.
here on number 29 on the court's docket.
Okay, that's CO 1927775-I, Judith Mendoza versus Perla Herrera.
Okay, Selena Padilla from Padilla Law Firm here for plaintiff. I do know Miss Aisa Garza is on the other side. However, I have not seen her on Zoom this morning.
Okay. Did you want our office to reach out, or did you want to make the announcement on behalf of both of you, or?
I can go ahead and make the announcement.
Okay.
The last hearing for this case, the parties announced that a settlement was reached. However, there was the property damage claim that was preventing us from being able to file the settlement documents with the courts. I suppose a bit of backstory that the insurance company wants to issue payment directly to the registered holder of the vehicle that plaintiff was driving. However, the plaintiff failed or did not register the vehicle when she initially purchased it. Therefore, our office is trying to reach out to the tax office and see what payments, what back taxes are owed in order to resolve the property damage claim.
Okay, so y'all need more time to do that.
Yes, Your Honor.
Okay, and do you have a time frame that you're looking at?
I know that this court appreciates realistic timelines, and so I would ask for at least 30 to 45 days, so that way we can come back with a productive status for the court.
Okay. February the 7th is the earliest that I have. If you all have your documents before then it won't be necessary for you to come at that time.
Okay, February 7th at 9:30 a.m.?
Yes.
Okay.
If you can please let Ms. Garza know.
I will. Thank you, Your Honor.
Okay, thank you. And I'll apologize to everyone beforehand. You're going to hear some baby talk probably in the background. My niece is here. So that's the perks sometimes of being at home. And the way she says hello is, hey, hey. So you'll probably hear her banging on my door saying that. All right, moving forward, Mr. Ramos.
Good morning, Your Honor. I'm here on number 10 on your docket.
Okay, F2111-20-9 in the matter of the marriage of Rodrigo Reyes and Kenya Reyes.
Yes, Your Honor. We're actually set today for a motion to consolidate. However, we're withdrawing that motion, and I believe we might be pursuing another avenue. There's a child support case that, unbeknownst to the clerk's office and ourselves, that was filed in another court. So I need to look into that, Judge, and see if I need to either file a transfer of this case over there or vice versa.
Okay. And the AG's office hasn't filed an intervention?
They haven't at this time, Judge.
Okay. Then how much time do you need in order to look at whether or not what it is that you're going to be doing?
Yes, Your Honor. I've already reached out to the Attorney General's office, and so we're looking into it. If realistically, Judge, if we can get a setting sometime, perhaps at the end of January.
Okay, February the 7th, I'll set you for a status just so you can let me know what you're going to do.
Will do, Judge.
February 7th at 9:30. Okay,
Yes, Your Honor, we'll be present, and I'm assuming we're probably still going to be on Zoom.
yes, yes. Well, that's what I've been told, and plus, it's not like I have a courtroom to take you to, but I'd have to borrow one. But as of right now, the hearings will be via Zoom, and you'll be notified accordingly if for some reason it changes to in person.
Will do, Judge. We'll be on the lookout.
Okay, thank you.
Thank you, Your Honor. May we
All
be
right.
excused?
Yes. Okay, Ms. Cohen?
Good morning, Your Honor. I'm here on number 15 on your docket, Yang Yin Aboitis versus State Farm Lloyds. I am counsel for State Farm Lloyds. And I'm looking for opposing counsel Willie McAllen. We just had a hearing. There we go.
Michael De Leon here standing in for the most honorable Willie McAllen. Cannot be present today due to a family emergency.
Okay, that's on CL 21-3183-I. And what are the announcements?
This is an application filed by Mr. De Leon or Mr. McAllen's client seeking the appointment of an umpire in a property damage appraisal going on that is currently ongoing. Each party has appointed an appraiser. The two appraisers have been unable to come to an agreement on the damage. So the plaintiff filed this application. The policy that's in place between the parties, Your Honor, requires that any umpire that is appointed by this court be qualified, and the policy defines qualified in this context as either an engineer or architect, an adjuster or a public adjuster that's licensed and experienced in estimating this type of damage, or a contractor that also has experience and training in estimating this type of damage. Someone that actually knows how to go up, roof at issue, look at the roof, determine whether it's damaged by the storm or due to some other reason, and to actually prepare an estimate or to agree with one of the other appraisers as to the line item detailed estimate, if there is going to be one. So the parties have come to you for appointment of an umpire. I do have a couple of suggestions, Your Honor. We just went through this in another court a little while ago. I have two suggestions that are actually experts that have been retained by the plaintiff in some of the lawsuits in which I've defended State Farm. So I have actually cross-examined these witnesses, deposed these witnesses. One of them I even cross-examined at trial as the plaintiff's expert. But I know these appointments are difficult, and all the parties desire an objective expert. So even though I've never hired these guys, and to my knowledge, State Farm has never hired these guys, I would suggest them to the court as umpires for the court's consideration. They're both from the Mission McAllen area. First is Jesus Ramirez with Custos Services. He is an experienced contractor, knows how to investigate and estimate damage due to storms. And my other suggestion is David Pointer, also from McAllen, and he's the one actually I cross-examined at trial for the plaintiff. Neither party, Your Honor, actually submitted a list to you in this case. Mr. McAllen's office and Mr. McAllen has filed about 7 or 8 of these that I'm personally involved in with State Farm as counsel. So neither one has filed a list with this court, but that's my suggestion to you on behalf of State Farm.
Okay, Mr. De Leon, any response?
Judge, our response is, well, I'll speak for Mr. McAllen. We'd object to those two names. However, we will provide, or have Mr. McAllen provide a list as to who he'd like the court to consider as an umpire on this particular case. I'm not familiar with either of those individuals. I've actually, the name is of David Pointer. I've heard that name, but we've actually never hired him as an expert on any of our cases. And Mr. McAllen neither has hired him as well. But again, we'll submit a list for the court's consideration. But as you know, Judge, we leave it up. Of course, it's up to you and whoever you'd like to appoint, whether it's somebody that's on opposing counsel's list or Mr. McCallum's list, or just somebody that you think is qualified. So,
And if I may, Your Honor, that is my point. I have not hired either one of the two that I've suggested. Plaintiff's lawyers have hired the two that I have suggested. An umpire is to be an objective determiner of the amount of damages, not someone that some other party has hired repeatedly. So that is why I made the suggestions to this court. And I would not suggest that either party present this court with a list of persons who they have hired as experts at trial, but quite the opposite, Your Honor. We need impartial umpires that are experienced in arbitrating between two appraisers that disagree as to damages.
Okay, I don't see that an order has been filed. So if I can get the order on that, and then I'll go ahead and take it under advisement, and I'll appoint somebody.
All righty. I believe we did file a blank order. But
I don't see it on here.
we
Do you
can
know what date?
Yes, sorry, I can pull it up.
The last thing I see is Rule 11. I saw that the response and the answer was filed. And an order setting hearing on the application for the appointment of an umpire, but I don't see the order attached.
You are
If
exactly
I
right.
may,
We will get a blank order on file today.
Judge, if I may, there's one from September 13th.
Let me see, order. Okay, yes. It's because it was titled differently. So it's already on here, Ms. Cohen. I'll ask for that to be forwarded to my queue.
Thank you, Your Honor.
Okay.
thank you, Judge.
All right. Thank you. Y'all have a good day.
You too. Thank you, Your Honor.
Judge.
Okay.
Bye-bye.
Okay, Mr. Reyna, are you in the room? Okay, Mr. Wilson? Attorney Paul Wilson?
Good morning, Your Honor.
Good morning. What number, sir?
Judge, I don't know which number this one is. I apologize to the court. I got the, this is CL 201527G.
Okay. Is it, okay, so CL 201527-I, Melissa Reyna versus Fatima Torres?
Yes, Your Honor.
Okay, and who are you stepping in for?
Well, I am here for the defendant, Fatima Torres. Melissa Reyna is represented by Stephen Gibson.
Okay, and was Mr. Gibson going to appear today?
No, Judge, he's usually pretty good about that. So if he's not here, I don't have an explanation as to why. He's not known to be derelict in appearing before the courts.
Okay, so do you know, were you all able to mediate this matter either informally or formally?
We mediated this case. The case did not settle. We've done written discovery. We've taken depositions. This case is ready to be tried.
Okay, if you'd like, go ahead and file for a DCC and we'll get you set.
Thank you, Your Honor. I have nothing further. May I be excused?
Yes,
Have a good day.
thank you. Likewise. Ms. Rivera, go ahead and set a tickler for December the 17th to make sure that that DCC has been filed by that date, please. Thank you. Okay, I have a Jose Peña.
Yes.
Okay, sir. And what case are you here on? Are you representing yourself?
Yes.
Okay. Are you here on a divorce or another civil matter?
Divorce.
Okay, and is that Maria Peña next to you? Okay, so Miss Peña, you were the one that filed for the divorce, ma'am? Okay, so you're Spanish speaking?
Por favor, sí.
Okay. Miss Castaneda, ask her if she's the one that filed for the divorce.
Miss Peña, ¿usted es la que metió la petición para el divorcio?
Sí.
Yes.
Okay, tell her that I'm gonna need for her to speak up when she does her responses.
Okay, la corte necesita que hable más fuerte cuando dé su respuesta.
Está bien.
That's fine.
Okay, let them know that I'm gonna look up to see if they have all the required documents for the divorce.
Okay. La corte se va a revisar a ver si tienen todos los requisitos en el caso.
Está bien.
That's fine.
Okay, so Mr. Peña, I see that you were served with the divorce back on November the 24th, 2020. Do you recall that, sir?
Yes.
You need to speak up, sir.
Yes.
Okay, you did not file an answer, however. Were you intending to file an answer, sir?
Yes.
Okay, so you need, you can also do your answer by appearing in person. However, I do see that you all have not filed your divorce decree.
Okay.
So are you and your wife in an agreement with the terms of the divorce?
Yes.
Okay, Ms. Castaneda, ask Ms. Peña if her and her husband have entered into an agreement with this divorce.
Miss Peña, ¿usted y su esposo han entrado a un acuerdo tocante este divorcio?
Sí.
Yes.
Okay, let her know that I need those terms to be set forth in a divorce decree signed by both of them so that I can review it.
Okay, necesito que ese acuerdo los ponga en un término en un decreto de divorcio para que la corte lo revise.
Bien.
That's fine.
Okay, let them know that as of right now, I wouldn't be able to hear them until February the 7th at 9:30. However, if they get that divorce decree entered and signed before then, she needs to call our office and I'll see if we can set her up sooner.
Okay, por ahorita la próxima corte que tenemos sería el día 7 de febrero a las 9:30 de la mañana, pero si usted entran, ponen el decreto firmado, puede llamar a la corte y la podemos poner antes de esa fecha.
Está bien.
That's fine.
Okay, so let them know that they're excused until that date.
Okay. Por ahorita se pueden retirar hasta esa fecha.
Está bien.
Oh, ask her if by chance she has a child support case open with the Office of the Attorney General.
Ms. Peña, ¿de casualidad no tiene usted una orden con la oficina del child support abierta?
No.
No.
Okay. All right, then I'll see them on that date.
Okay, entonces lo miramos en esa fecha de febrero.
Gracias.
Thank you.
Okay. Mr. Reina?
Good morning, Judge.
Good morning.
I'm here number 36 for status hearing. I just haven't seen opposing counsel.
Okay, you're going in and out, but I kind of got it. CL 15-3093-I, Lurie Alejandro Duarte et al. Versus Jose Luis Soto et al. Mr. Munoz?
Yes, Judge Sergio was here on behalf of Mr. Duarte, the Duarte's, Your Honor.
Okay, and what is the status on this case, gentlemen?
Judge, I think we just need maybe a DCC so we can get a pretrial and trial setting. I did already get the information, the discovery issue from Mr. Reina resolved.
Okay.
So I think I could file an order setting hearing for a DCC or whatever the court would instruct us to do, Judge.
Okay, have you all attended mediation?
No.
Okay. then what I'm gonna do is I'm gonna submit an order referring you to mediation. And then we'll take up the issue of the DCC. What kind of case is this?
It's a property case, Judge, where there was a property that was sold, and the issue was whether or not the individual that sold it had permission, and whether my client was a bona fide purchaser.
Okay, so somebody with real estate knowledge.
Yes, ma'am.
Okay. All right. Okay, then I'm gonna go ahead and send that referral out. It'll have some deadlines on there for you for future settings as well. Okay,
Thank you, Your Honor.
all right. Anything else, gentlemen?
Nothing
from me.
further, Judge. May I be excused?
Yes, you all may be
Thank you.
excused. Thank you. Okay, Ms. Vela?
Good morning, Your Honor. I'm number 23 on your docket.
Okay. That's F 3712-16-9 in the matter of the marriage of Dana Ray Alvarez versus Peter Alvarez.
Rebecca Vela for Dana Ray Alvarez.
Christopher Castillo standing in for David Flores, for Mr. Alvarez, Pete Alvarez.
Okay, and what are the announcements?
Your Honor, we have filed our fourth motion to compel on discovery matters in this, and we have also filed an additional motion to compel on a second set of discovery that was sent out and due on the 19th of last month. While we were waiting, Mr. Castillo and I spoke regarding what we were looking for that was ordered. So we have discussed that, but I still have, again, this is a fourth motion. The responses were due back in June. We've received some responses. They were not complete responses. At the last hearing that we had where Mr. Flores and the client were both present, this court gave them an additional 30 days to get those discovery responses. To date, I still don't have them. They have completely disregarded this court's order multiple times on this, and I shouldn't have to be filing motions to compel in order to receive discovery responses. We're asking for sanctions to be awarded on this. I'm asking for sanctions in the amount of $6,000 for all of the motions, my preparation, and the hearings that I've had to attend to simply get discovery responses so that we can go and mediate this case and reach some sort of a resolution, or attempt to reach some sort of a resolution on this matter.
Okay, and Mr. Castillo, your response?
Your Honor, Ms. Vela is correct. We did have a conversation. As far as providing complete responses, as far as the fourth motion to compel, I think a lot of the questions that she has will get cleared up with the second set that she sent out, as far as the request for production. On our end, I will be filing a notice of appearance as co-counsel, Your Honor. I've been trying to get Ms. Vela, or working with my office to try to get everything that Ms. Vela needs. We're not going to withhold anything. It's an issue internally on our side, Your Honor. But we do intend on providing everything that she's requesting. We're not going to withhold anything. And Ms. Vela and I did clear up exactly what she needed over our phone conference prior to being called today, Your Honor.
Okay, look, this is what we're gonna do. I'm gonna have a special link sent out to you all on for December the 8th at 3 o'clock. We're gonna have a conversation, the attorneys and us. It's gonna be in chambers. Do y'all understand that?
Yes, Your Honor.
And then we're gonna discuss this a little further, and we're gonna get to the bottom of this, okay?
Yes, Your Honor.
All right, and my court coordinator will send you all an email the day before, and it'll be for Wednesday at 3 o'clock.
Yes, Your Honor.
If I change my mind and need to do it in person, I'll let you all know at least the day before so that you all can come into my chambers.
Sounds good, Your Honor.
Thank you.
All
Your
right,
Honor.
so I'm gonna hold
Thank you.
over any ruling until after that discussion.
All right, thank you.
Thank you, Your Honor. That's all I have. May I be excused?
Yes, you all may be excused.
Thank you.
Thank you.
Thank you.
All right. Okay, I know the last two issues that I have are gonna be contested, so let me see if there's anybody here that is not for a contested issue. Mr. Guerrero, is yours contested?
I'm here, Judge. I'm here on the case of Mr. Alexi Ramos, Your Honor.
What number?
I don't have the number on the docket, but it was set for a status.
34, Judge.
Thank you. Okay, F 3450-09-9, and is Mr. Sanchez still on the other side?
Yes, as far as I know, Judge, just so the court will be aware, I mean, this case, when it was in County Court number 1, when he was a judge, Rudy Gonzalez was a judicial officer. We had a Rule 11 agreement on the sale of the house. And I neglected to tell the court last time we had a status hearing, and it was on the record. I don't think they're opposed to doing that. The only thing that had been pending is the proof of the efforts to try to sell the home. I did reach out to Sergio the last time we had this matter set for a hearing. He did not get back to me, Judge. What I would suggest, Your Honor, is let me get something in writing or pull the transcript, or we make that agreement on the record, and then I'll figure out what I need to do if it hasn't been refinanced, if the home hasn't been refinanced yet. And that's my announcement.
Okay, so that I don't lose you or track of the case, what I'm gonna do is I'm just gonna hold over the status till February the 7th
Okay.
at 9:30, and that'll give you time to try to resolve whatever's
February
pending.
7th, 9:30.
Yes,
Thank you, Judge. May I be excused?
yes, you may. Okay, who is, okay, Mr. Sanchez, what case are you here on? Victor Sanchez.
I'm here for case number 24, Jose Trevino versus a number of defendants. I'm here for Ms. Iona Saenz. And I apologize, I got word from my staff to immediately get on the call. It's a little over 9:30. They had thought it was just like a docket control, just kind of work out trial dates, but
I'm sorry, that's not what I have for number 24 on my docket.
Did
Do you
he say,
have- I'm sorry?
what's the cause number, Judge? I'm sorry.
I've got CL 194038-I. This is reset from October 27th because we're missing one of the parties, but I'm not sure if we're missing someone
I
now.
think it's number 35, Judge, if I heard the correct cost number.
Okay, and is it Jose Liu Trevino versus Iona Santana Saenz?
Yes, Your Honor.
Okay, yes, that's CL 194038-I, it's number 35 on the court's docket. And you're representing which party?
Ms. Saenz.
Okay, and so Ms. Garza, Ms. Ramirez, and Mr. Caso, have you heard from them?
I have not, and I believe one of them is the party with the insurance issue. Apparently one of them had ACC insurance and they went bankrupt.
Oh, okay.
Stay on there, but I don't know what the status of that is.
Well, so far you're the only attorney that has showed up on that case. Yeah, so I don't know if you have a good status to provide the court with.
Not at this time. Ours is pretty simple. It's one of the other defendants that has the insurance issue. But I think the issue might have been because I'm looking at the October one, and there was an order resetting it from the October setting to today for the status conference. I don't know if they had gotten that.
Okay. Well, what I'm gonna do is I'll just go ahead and reset the status for February the 7th at 9:30.
Okay.
And hopefully at that time, all the attorneys will be on.
Okay.
All
Sounds
right.
good. I'll get my staff to send a message out to it. But February 7th?
Yes, at 9:30.
Okay. All right. Thank you very much, Your Honor.
Okay, thank you.
May I be excused?
Yes, you may.
Thank you.
Okay, before we take up the contested matters, let me see. Okay, you have, it's Cesar. I do not know. Can you unmute yourself and tell me?
Yes, Your Honor.
Okay, what case are you here on?
For divorce, case number F-2796-21-9.
Number 8, Judge.
Okay, and is Ms. Toscano present?
I don't believe so, Your Honor.
Okay, let me look up your case very quickly. Okay, so Ms. Toscano did file an answer back on June the 29th.
Yes, Your Honor.
Okay, notice was sent to her. Let me see. At the last known address at 1320 East Medcap Drive in FAR. You all filed a proposed divorce decree on December 6th today.
Yes, Your Honor.
And y'all have no children?
No, Your Honor.
Okay. So the divorce decree that you filed today only has your signature and it does not have her signature, so I can't accept it.
Okay.
So you need to have that divorce decree signed by her as well.
Okay.
And also, if you have an email address, do you have an email address for her?
The original answer that she had put, it should have her email address on that one.
Okay, let me check. Yes, you are correct. She did, and that is at TOSCANOLIZ40@gmail.com. Okay, so we're going to have to we're going to have to reset you. So what I'm going to have to do is, let me go back and look at your. Did you file that order setting hearing date? That was you, right? You filed, remember that order setting hearing date that you filed back on October?
I believe so, Your Honor.
Okay. So what I'm gonna need for you to do is file another one, but you're gonna call it order resetting hearing date.
Okay.
And then I'm gonna need for you to also put her email address on there. So get that filed and we'll give you a new date and make sure that before then she signs that divorce decree. And then we can go ahead and have you divorced at that time.
Okay, Your Honor.
Okay?
Yes, Judge.
Okay, thank you.
Thank you, Your Honor. May I be
All right.
excused?
Yes, you may.
Thank you.
Okay, who is on iPhone right here?
It's me, Your Honor.
Okay, what is your name again? I'm sorry.
Jorge Luis Carrizales.
That's my client, Judge.
Oh, okay, so that's on your case. Okay, thank you. Okay, we'll be right with you. And who do we have on iPhone here? All right. And Ms. Escalante, what case are you here on?
Judge, she's my client.
Oh, okay. All right, then I guess, I don't know who that is that's on iPhone. They're not responding. So we're gonna move forward with the contested matters, but we will be on a 5-minute break. When we come back, I'll take you all up.
Thank you, Judge.
Ms. Flores, are we ready?
Yes, Judge, ready.
All right. Okay, let me just wait for the attorneys to come back. Mr. Rayfield, Mr. Reyes?
Yes, sir.
Yes, Judge.
Okay. And Mr. Rayfield. All right. Give me one moment.
Your Honor, I'm not party to this motion, Your Honor. I'm here for number 39 on your docket.
Oh, I thought you were with Mr. Bruneda's case.
Yeah, Leo Pruneda. Yes, that's correct.
Okay, yes. So it's CO 18-6390-I, Angelita Brunedo et al. Versus Gregory Funding et al. Announcements?
Judge Shelley Hopkins for Gregory Funding and U.S. Bank.
Good morning, Your Honor. Tom Rayfield here for Mr. and Mrs. Pruneda.
Okay, and what are the announcements?
Judge,
Sorry, go ahead. I'm sorry, Shelley. Go ahead.
So we're ready to proceed. I assume that Mr. Rayfield's going to announce not ready. So go ahead. Sorry.
Thank you. Your Honor, we're not ready, Your Honor. We had filed a motion for continuance for the last hearing. I just got notification from Mr. Pruneda that he's up at MD Anderson with his wife, undergoing more treatments, and we can provide proof of that to the court. But we would ask this matter to be reset because of the illness of Mrs. Pruneda and the fact that Mr. Pruneda is basically taking care of her, Your Honor.
Okay, Ms. Hopkins, I'll give you an opportunity to respond.
We don't want to be the bad guy here. I understand he's dealing with some personal issues. We've just been waiting for quite some time to get this motion set. I would just request if we get another continuance, can we go ahead and get a trial setting as well, so that we can work towards that. We haven't mediated because mediation was canceled, discovery wasn't complete. I just need to be able to tell my client there is going to be some resolution at some point in time, besides just a reset of the hearing.
Okay, so actually, Mr. Rayfield, before you got on, I did let Ms. Hopkins know that I was very well aware because of a previous hearing that Mr. Pruneda had last week that he stated that he would be in Houston for approximately 2 months. And so I'm going to grant his motion for continuance. And Ms. Hopkins, if you can file an order resetting hearing, and we'll probably set it out for about 90 days. Also, in the meantime, you can also file a motion for a DCC, and we'll get your DCC set with trial and pretrial dates, and that'll give you your deadlines for discovery and mediation and any of those other things just to continue with the case.
Thank you, Your Honor.
Very well, Your Honor.
Okay, anything else?
Nothing
I
further.
believe that's it. May we be excused.
You certainly may.
Thank you. Have a good day.
Okay, thank you. Okay, so Mr. Reyes and Mr. Davis, it's F 4767-21-9 in the matter of the marriage of Jorge Carizales versus Jacqueline Escalante. Announcements first before we get into any testimony.
Your Honor, Samuel Reyes for Jorge Carrizales. Judge, we are present and ready to proceed.
Judge Tim Davis for Ms. Escalante, we're present and ready as well.
Okay, so Mr. Reyes, before we get into anything, can you just state for the record the basis of your motion for today?
Your Honor, the reason I filed the motion is because my client, it's been some time since he's been able to actually have access with his children. And he does work out of town, but when he comes back into town, which right now I'm going to get some testimony about his schedule, he's tried to have some access, see how his children are doing, and he's really been struggling to get any sort of information on the children, be able to speak to them, have FaceTime, or actually have some in-person contact with them. And that's been going on already, Judge, over a month that he has not been able to have any. So that's just the reason for the emergency, Judge, is that there's been no contact with his children. Certainly it's harmful to the children to not have contact with their father.
Okay, so how old are these children?
Judge, it's a 4-year-old and a 2-year-old. And
Okay, and Mr. Davis, I'll give you an opportunity to put on the record, what is your client's hesitation in allowing Mr. Carizales to visit with the children?
Well, no, she's okay with him having visitation. I think, as Mr. Reyes said, some of the issues are he works out of town. So he had come in. My understanding from talking to my client is he was here at the end of October when their daughter turned 2, and he took the children for a while and everything, and that was fine. Then there was another time about a month later where there was some confusion because apparently there had been a temporary restraining order signed, and it was relayed to my client that he was getting custody of the kids and things like that. But I went through that with her and said, no, that's not the case. And she understands he's entitled to visitation. Now, part of the issue is, Judge, obviously their daughter's only just barely turned 2. Their son is 4, but he does have some developmental issues with autism. So at this time, I was talking to Mr. Reyes, my client could agree to visitation whenever Mr. Carrizales is here in town, with, like 24 hours notice, but she would be hesitant at this point for any overnight visitations because of those issues.
And Mr. Reyes, is Mr. Carrizales asking for overnight visits?
He is, Judge. He's a very good, loving father, Your Honor. His children, his son with autism has been very accustomed to always being with the 2-year-old sister. And we believe that it would be in their best interest to stay together with overnights. When he's down here, he has a support system. Mother and father were very supportive. His sister, they're all willing to help him when in the times when he is down here. And we are in agreement to the degree that when he comes down, he does get the visitations with his children, since it's not necessarily going to be every first, third, and fifth weekend, but his schedule does vary. But when he does come down, that he has those visitations, I think right now the rub would be that they don't want overnights, and we feel that he would do good with overnights. Seeing as how he does have a support system. We'd also be asking that when he is out of town, that he have some type of, daily FaceTime with the children, maybe 20 minutes from 8:30 to 9, so that he can continue to have ongoing contact with him. There's never been any sort of concerns with him, about, the safety, the welfare of the child, and him being taking good care of the children. So I think that really would be the issue, and we certainly we appreciate them offering that he does have contact when he comes down. But yeah, there's never been any issues with him, Judge.
Okay, I'm going to ask you all to accept the invitation into virtual chambers, the attorneys.
Very well, Judge.
Okay, Ms. Flores, are we ready?
Yes, Judge, ready.
Okay. So we are back on the record on F 4767-21-9. And before I address the parties, I'll go ahead and give the attorneys an opportunity to speak. Mr. Reyes, you may go first.
Your Honor, first I wanted to ask my client if he could tell the court what his current schedule is at this time. Mr. Carrizales, if you would.
Yes, Mr. Reyes, thank you. Good morning. My name is Jorge Carrizales. Recently, I was telling Mr. Reyes, I recently got a promotion like a couple of days ago, before my schedule was kind of off. So I would have like every 14, 15 days, I would just have one day off. And I know that's not going to give me enough time to get out of work and drive 9 hours back home and then drive another 9 back over here. So I would stay here. But recently at the position that I'm in right now, their schedule is different compared to at the position that I was. So the way their schedule works is they work 14 days straight and they have 2 days off. I'm still working on trying to get the schedule to show on my, it's a website that we call Schedule Anywhere. I'm still trying to reflect it on there so I can have proof that I'm working 14 and then 2 days off to be able to give me enough time to go back home. But as of right now, that's what I'm being told, that's going to be my schedule, working 14 days and having 2 days off. And it's not like a Friday, Saturday. It's just like a work 14 and then 2 days off.
Thank you, Mr. Carrizales.
Okay.
Your Honor, what I would like to propose, and my client has, Mr. Carrizales, when is the last time that you actually had contact with your children?
Last time, can't remember, it was maybe like a week ago, or maybe a week and a half. It was through FaceTime, I believe.
Okay. So Judge, what I'm requesting on behalf of my client is that schedule, that the order of the court be that when he does come down from his work, which as you heard, it's not very often, but that when he does come down, that he be able to have that time period with his children. And being that his son and Mr. Carrizales, can you tell the court about your son and how his routine is to be with his sister?
Yes, of course. Yes, definitely. I know, I mean, my son does have autism, so I know that autistic kids, autistic persons, like they have their own routine. And I know that breaking the routine, changing it to something different, like it does sometimes shut them down, or they change their personality. And ever since my daughter was born, they've literally been together like 24/7. At as I told Mr. Reyes a couple hours ago, that when Mika was born, like my son would like kind of stay back from her because it was like it's something new that he was seeing. And until a couple of months later, that's when he started like getting comfortable enough with her. But ever since she was born, like they literally do everything together. They go out together. And I know, me being over here and they're with their mom, like I know she likes to keep them together. So I know they're always constantly like seeing each other, waking up, sleeping together in the same bed and stuff like that. So I know I would
like them to stay together, correct?
Would love for them to stay together. I know I'm a great father. Like I know being with them overnight, maybe like at least one night or 2 nights, the meantime that I'll be down there, I know like I'm more than capable enough to take care of them. And I mean, of course, I have no problem taking him back to their mom. I mean, because I feel comfortable enough to take them back to their mom because I know she's a great mom as well.
Understood, Mr. Carrizales. I appreciate that. So, Your Honor, what we're asking for is that when he does come down, that he do have contact with the children, and we would ask the court to allow him overnight with both of the children so that they can stay together. We would also ask the court to allow him maybe a 20-minute block of FaceTime when he's not here, each night, each evening, to allow him to have regular contact when he's not here, and that this be the temporary order, Your Honor. So that would be our request.
Okay, Mr. Davis, you want to respond?
Yes, ma'am. Judge, if I can ask Mr. Carrizales a few questions also.
Sure.
Where do you work at? What location?
I'm located at Pecos, Texas.
Okay, and so that's about 9 or 10 hour drive from the valley, correct?
It's 8.5. Yes, sir.
8.5. Okay. And you said that you'll get 2 days consecutive off after you've worked 14 days?
Yes, sir. That is correct.
Okay. And how far in advance will you know that schedule?
That's what I'm trying to find out right now. Because the system that we work, it's a new system that they're trying to put the schedule maybe 4 days in advance. But the thing is, sometimes they do change it 4 or 5 days before. So I want to make sure that I can have a set schedule so that I can let Jackie know, what, I have this set schedule. I can let her know maybe in a 3 days notice. And I know once with those 3 days notice, I know my schedule is not going to change.
Okay, so you'd be able to give her at least a couple days notice.
Yes, yeah, definitely.
Okay. So what time do you normally get out of work?
It varies sometimes. I go in at 7:30. I get out at sometimes 8:10 p.m. So it's almost like a 13-hour shift, and that's around the time that I get out.
Okay, and then if you were going to come home to the valley, so you either have to sleep and then wake up and drive real early, or try to drive straight through, right?
Yeah. Last time what I did was I got out of work at an hour earlier, sometimes at 30 minutes early, just to have the drive. And I got there around 5 a.m, and I was able to have a couple hours of sleep. By noon, I was already, or maybe 11, I was already up to start my day. So getting there and isn't any issue at all.
Okay, and then you'd have to, obviously, when you return to work, you have to do the same 8.5 hour drive back to Pecos, correct?
Correct. Usually what I do is take off from the valley around 6 p.m. maybe. Not too late, because I know there's a lot of deers and raccoons over here on the way over here. So I would get here maybe around 12 a.m., 1 a.m. and have enough time to be able to have my rest and go back to work. The good thing is that where I'm located is 5 minutes from work, so it's not a big problem.
Okay, and obviously you're not asking the court to allow you to take your children to Pecos to the work site, correct?
No, what I want to do, I just want to be able to have that access. I don't want to have more than what she's doing right now. I feel like I can have a requesting, be able to have a say in their education, their medical, continue doing the same thing as if we were still together, but just being parents to our kids. That's it. Being involved with everything that they are involved in.
Okay, I'll pass the witness, Judge.
Okay, Mr. Reyes, do you have any follow-up questions?
No follow-up, Judge. Just that we would request that they be temporarily appointed joint managing conservators, and that the court order FaceTime and overnight when he is down, a modified possession that would take place when he gets down with a 2 to 3 day notice that he would provide of when he is going to be down, and that when he is down, he does have that time with his children.
Okay, so this is what we're going to do. So, Mr. Carrizales, you're in a very difficult position, and I do appreciate that. In other words, I understand it. And I know that you want to step up and being a father, but we also have to do a balance, which is because you have, 2 little ones, of which I call a tender age. a 4-year-old and a 2-year-old, and your 4-year-old is special needs, but it sounds like, you know, you do know what's going on with your kids. So I understand that at the beginning, there's a lot of uncertainty, especially when, you know, Ms. Escalante got served with the papers, and sometimes that puts people on the defensive.
Right.
But what we're going to do in this situation is we're going to do something very, very temporary. Before I became a judge on the bench, I practiced family law for about a little over 19 years. So I'm very familiar with what it is to be in your attorney's shoes. And I've seen all different types of scenarios, all different types. So I'm going based on what you're saying and what my experience has been in these situations. So we're going to do something very short. I have already ordered you and Ms. Carizales and Mr. Carizales and Ms. Escalante. I've ordered you all to go to mediation. So you will be mediating this matter, and your attorney's are already working on dates for sometime in the beginning of January, because that is a requirement of the local rules and it is a requirement of this court. I'm also going to, I will appoint you joint managing conservators, with mom being the primary managing conservator. And you will have equal rights at this point as to equal rights and duties. Now, I'm going to require that when you do come down between now and that time, that you do give Ms. Escalante at least 48 hours notice of what your schedule is going to be. Now, your visitation period will consist of an 8-hour visitation period. At this time, there will not be overnights. However, Ms. Escalante, that does not mean that I will not order overnights later. It's just that for right now, I just want something through the holiday period, because I want to make sure that both of you have access to the children during the holiday period, which means that if Mr. Carizales is able to come down for the Christmas break, I have already instructed the attorneys that one party will have the children for Christmas Eve and one party will have the children for Christmas Day. That is a fair distribution of time with the children. Mr. Carizales' periods of visitation will extend for an 8-hour period. Okay, he will have daily telephonic access to the children, which will be via FaceTime. However, Mr. Carizales, be reasonable. Children don't always stay on longer than 30 seconds, 1 minute, or anything like that. I'm not going to set a time limit. I'm expecting you all as responsible parents to decide how long those FaceTimes will last. I don't anticipate they'll last very long, because it is difficult to be able to keep a child's attention during the time period. But I anticipate, Mr. Carizales, that the whole point for the FaceTime interaction will just be so that your children can continue to see you and so that you know how your children are doing. During this FaceTime interaction, I will state neither party is to be asking the other party personal questions, such as, where are you? What are you doing? What did you do today? Did you do this? Did you do that? Who were you with? That is none of your all's business as to what each other is doing personally, unless it affects the welfare of your children. Your FaceTime conversations will be just as to the children. How are you doing? If they're in school, how is school? How is daycare if they're in daycare? Do you feel good? Just things of that nature. Your jobs are to be parents and to give these children as easy a transition into post-divorce life as possible. That is your responsibility as a parent. It is not your responsibility as a parent to drill your children with questions, okay? That affects their mental health and that affects their well-being. You want to be a positive influence in your children's life. You do not want to be hurting your children. That goes for both of you. So just because Mr. Carizales is having an 8-hour period, it does not mean that he will not get overnight visits. Like I said, this is very temporary. This is just so that we can do something for now to ensure that the children spend time with both parents, specifically over the Christmas holiday. You all will come back on January the 26th at 9:30 for a status conference. I am hoping at that time you will be proving up a settlement agreement for your extended temporary orders. You will be attending mediation prior to that date with Ms. Diana Fuentes Aguilar, and your attorneys both have all of that information. Each of you are also to exchange any personal information, such as phone numbers for one another, emails for one another, and addresses where you can receive mail. Also, I have instructed Mr. Carizales for your attorney to turn over pay stub information to Mr. Davis so that child support can be calculated as part of the temporary orders, because that does need to start, or else you'll find yourself with questions with respect to whether arrears is owed or not owed, okay?
Yes, Your Honor.
So be very careful on your drive. I'm sure that Ms. Escalante can also appreciate the fact that you're 9 hours away. Look, although your marriage did not work, it does not mean that your parenting together cannot work. And it is difficult. So you all have, I mean, every child is special, but your children are a little more special at this time. So I expect that you all will co-parent effectively and will talk to one another. Nobody is going to win here if you want to backstab each other or cut down one another, or say that one parent is not good or anything. Any negativity that comes from co-parenting will affect your children and will also affect you. So the goal is always to try to transition out of this divorce and get into post divorce life with as healthy of an attitude as you can. So you all have your work cut out for you. And like I said, this is very temporary. This is just so that we can get you through the next 30 to 45 days. All right?
Your Honor, for the daily FaceTime, can we agree like on a time like 8 p.m. or?
I'm going to let you and Mr. Davis speak about that, because I'm sure that the children have a routine. So I'm going to ask that you also work with Mr. Carizales' schedule. And if he can take a short break during shift work to do the FaceTime, then do it during that time. If not, then work with one another. But I'm not going to force you all to come to that agreement right now on the record. I'm going to trust that you all as, of course, the great attorneys that you all are, and your clients, listening to where the position of the court, I'm sure you all can come up with a time.
Thank you, Judge.
Okay. Now that will be the order of the court, and I'll see you all back here on January the 26th at 9:30 a.m. I wish you all a very merry and blessed Christmas holiday season, and I pray that you all are able to get through this as best as you can. All right?
Thank you.
Thank you, Judge.
Okay. You all are excused.
Thank you.
Okay, I have a Sandra Villarreal that's showing on my screen. Ms. Villarreal, what are you here for?
Sí, buenos días.
Okay, buenos días. ¿Está aquí en un divorcio?
Sí.
Un momento. Before we get Ms. Castañeda on, I'm going to check, because I don't think they perfected the service here.
That's correct, Your Honor. It was not.
Okay. Ok. So, señora Villarreal, es porque el documento que usted metió el día 27 de agosto debería de ser firmado por su esposo, no por usted.
No, pero entonces están mal los documentos.
Sí. Y también, y si esa es la firma de él, la firma era antes del día que usted metió el divorcio. Ese documento, si él es el que lo firmó, tiene que estar firmado después de
Él fue
la
el que,
fecha.
perdón, él fue el que pidió el divorcio. O sea, yo le firmé los documentos
Ok.
que ellos me dieron.
Usted lo firmó el día 16 de agosto y él metió el divorcio el día 27 de agosto. So necesitaba que estar firmado después del día 27. Solo necesita que firmar usted otra vez.
Después del día 27 de agosto.
Sí, usted lo firmó el día 16 de agosto.
Okay.
Debería de estar firmado el día después del 27 de agosto.
Porque yo le firmé a él unos papeles el 27 de octubre, el día que tuvimos la corte que se canceló. ¿Nos
Sí,
habían
pero
comentado eso?
ok, pero ese documento era el decreto del divorcio. Eso es diferente.
Ok.
So necesita que firmar el waiver of service otra vez. El que firmó usted enfrente de una notaria.
Sí.
Ese documento necesita que estar firmado otra vez.
Otra vez.
Sí.
Pues ya le he firmado a él no sé cuántos papeles, no sé por qué está mal, ¿verdad?
Porque, sí, pero porque le estoy explicando. Usted lo firmó el día 16 de agosto y esa fecha no lo puedo aceptar. Nomás
Sí,
puedo
pero
aceptar fechas después del día 27 de agosto.
sí, pero yo le volví a firmar esos después
Usted-
del 27 de agosto. No sé qué pasó en realidad.
Él no lo entregó entonces.
No, posiblemente.
So, antes de hacer este divorcio, necesita usted que firmar ese waiver y lo tiene que meter y luego podemos hacer este divorcio. Y él no se ha presentado hoy tampoco.
Sí, sí está. Lo que pasa que él dice que no puede hablar, que no encuentra el micrófono en su pantalla. Él está
Okay.
desde que comenzó la corte.
Bueno, van a regresar ustedes el día 7 de febrero a las 9:30 y necesita que estar firmado antes de esa fecha.
Está muy bien.
¿Ok?
Ok. ¿Y dónde lo llevo? Cuando esté firmado, ¿a dónde lo llevo?
Aquí en la casa de corte.
Está muy bien. Muchas gracias.
All right. Okay. All right, let me go down the docket. Okay, on number 1, did anybody call in?
No, Judge.
Okay, then that's dropped. Number 2,
Nothing as well, Judge.
okay, then that's dropped. And I'm sorry, that's at CO 1435110-I is dropped and F 3039-20-9 is dropped. Okay, and number 12.
Number 12, Judge, there is a Rule 11 and an order resetting.
Okay, number 14.
Same announcement, Judge.
Okay. And number 15. Oh, that's for me to decide. Number 16.
Judge, I sent out the link, but I'm not sure. Nobody called in, and I don't have an email either that was returned to me, so I'm not sure what happened.
Okay, well, set them then for a status on February 7th. If they want the motion reheard by then, we can hear it.
Okay, Judge.
Okay, number 30.
Number 30. I mistakenly sent the email, Judge, to a wrong email. It was returned to me, so I will be resetting this case.
Okay. On 32, go ahead and set a tickler for December the 17th for that order setting hearing to be filed. If not, I'll lose track of it.
Yes, ma'am.
Okay, on number 36, we'll send out the order of referral to mediation. And then 39, they're gonna send an order resetting hearing. We just did 40. Okay, I skipped a page. Number 17.
That's an order, it's a Rule 11 and order resetting.
Okay. Number 19.
Number
Oh.
9. I think it's 21, Judge. On number 19, those were urged.
Oh, that's right, sorry. Yeah, 21.
Okay, 21, Judge. This is the case that we heard last time, and it was, he did the background check solely for Hidalgo County.
Correct.
And so we're pending the state of Texas from DPS, and it has not been filed. I didn't find a correct email for him, so I'm gonna see if in his petition there's a phone number, Judge, so I can get in contact with him.
Okay. All right, I think that concludes this morning's